Well, we have another judge behaving badly. A sovereign citizen, a Moorish sovereign citizen, is reading from a script. The judge is telling him to stop talking right before jury selection. And the sovereign citizen is saying that, of course, there's no jurisdiction over him. The judge had enough. It turns out the guy was wearing a 50,000-volt ankle cuff. And so the judge tells the bailiff to shock him, which I'm sure hurt like hell. This sovereign citizen then sued the judge, claiming that what the judge did violated his civil rights. But because the judge issued the order to shock the sovereign citizen, the judge had judicial immunity. And this led to other cases in California, one of which was a public defender who a judge ordered to be brought into the courtrooms. He's tired of the guy just hanging out and bullshitting around. A lot of lawyers do that. They don't want to come into the courtroom. Judge told the deputies in LA County, bring body parts if you have to. And so they roughed him up, dragged him through the doors, threw him down basically in front of the judge. Public defender took a lot of exception to that and sued. And this case went all the way to the Supreme Court, the Supreme Court. So anyway, you know how lawyers are. We're rather just a bunch. So let's take a look. This is actually kind of an interesting case.
Mr. Sheriff, do it. Use it.
That was faster than P. Barnes.
I'm going to take 5. Don't he calms down, and I'll be back.
Yes, sir.
5 minutes.
Delvon King was as a Moorish sovereign citizen, and he insisted. The judge asked, "Well, how do you want me to address you?" And he wanted to be addressed as King Ali. Okay. Anyway, let's go through some of the district court lawsuit that King Ali filed against the judge, Judge Naley. And the cuff sent thousands of volts of electricity through King's body, causing him to collapse in the middle of the courtroom and scream in agony. King was addressing the court, not endangering himself or others. King had the cuff around his ankle because he was, I think, a flight risk of some kind, or he escaped anyway. It says, after Judge Naley repeatedly asked King how he wished to be addressed, King agreed to be referred to as Mr. King Ali. Then he launched into a prepared argument asserting the trial court lacked, guess this, jurisdiction. Nope, because he's an Aboriginal Indigenous man. Now, voir dire questions are those for the jury. After Judge Naley ordered King to stop his jurisdictional argument, Judge Naley directed the sheriff to do it, use it. King had not raised his voice, moved from counsel table, or made any aggressive or threatening statements or actions. That's true. At this point in time, Ali is just simply discussing, he's in contempt because he keeps talking when the judge tells him to shut up. But this happens a lot in court, and it would not warrant zapping him like this. I think that the judge kind of snapped on this one. I think the judge was wrong to do this because otherwise there would be a lot of people getting tased in court. That the judge Naley was disqualified from serving as a judge, and then he was charged criminally for depriving him of the rights under the 242, depriving under color of rights. He pleaded guilty, sentenced to 12 months of probation, of $5,000 of fine, and anger management counseling. So the judge did not do any time. And then judges have absolute immunity from civil lawsuits, and the district court looked at it and said, since this was done as an order carried out to a bailiff or to a law enforcement officer as part of his judicial duties, there's no lawsuit against the judge for that. There are exceptions, of course, and this was the other case I want to show you, Morales in Los Angeles, where if it's not directly related to judicial duties, such as the other judges behaving badly, where that guy just wanted to beat the crap out of the public defender, no immunity for that. It says the immunity extends to judicial action taken erroneously, maliciously, or in excess of authority. This way, judges are free of lawsuits. Then they give some interesting examples from across the country, this opinion. In Morales, the Supreme Court held that a judge was entitled to judicial immunity after he ordered police officers to forcibly and with excessive force seize and bring an absent attorney to the courtroom, which resulted in the officers using unreasonable force and violence against the attorney. Not only they break him through the doors, just roughed him up, right? Judge Naley's improper order to activate the stun cuff was a judicial act because it was taken a part of the general function of maintaining order. That's true. And in Los Angeles County Municipal Court judge, the municipal court was merged to Superior Court. Muni court would be like traffic tickets and shit like that, low dollar cases. Ordered the use of a stun belt on a criminal defendant in a courtroom. That was something. Now, Ali had a stun cup. This was a stun belt around his waist. Man. The judge asserted the defendant made several statements out of order and acted in a general disruptive manner, and alleged the judge had sought to silence his speech and acted in bad faith. But still, this is in response to maintaining order in the courtroom. There's immunity. Here is Meyerless and Hawkins illustrate the fact that Judge Nally ultimately exercises judicial discretion in an unwarranted, unreasonable, and unlawful manner. He still has immunity. This is another case I looked at. A judge received judicial immunity even though she ordered a completely unnecessary strip search and body cavity search in view of male law enforcement of an elderly woman. I looked at that case. That elderly woman obviously was so mortified about what was going on. I mean, a strip search and body cavity search, that she actually lost all control of her bowels and was brought back into the courtroom like that. Oh my gosh. I mean, come on. Really? Another judge received immunity even though he berated an attorney with a long string of offensive and threatening epithets, including some related to the attorney's ancestry. Again, something about lawyers, man. You pull this shit on us and we tend to go off, okay? Threatened the attorney with physical harm in jail and forced the attorney to publicly recant a prior public campaign about a trial's fairness. Another judge received immunity after approving the sterilization of a young woman. Did you guys know that there was I think it was Oklahoma v. Skinner, where a state in Oklahoma, if somebody, suffered from a mental disability and had an IQ below a certain amount, that the state could forcibly sterilize its own residents. A plaintiff sought damage under 1983. Those are the civil rights cases. After a state court judge unsuccessfully ordered the plaintiff to leave the courtroom, then forced the plaintiff out the door, threw him to the floor in the process, jumped on him, began to beat him. My gosh, he could attach. I mean, no immunity can attach. And so once again, and of course they have to throw the humor in. In order to electrocute King, his order to electrocute was a shocking misuse of judicial power. Okay, they do these things. So the lawsuit was dismissed. Then he appealed it. And the appeal court agreed that the judge was performing the judicial act of maintaining order when he directed the activation of the stun cup. He's therefore entitled to judicial immunity. So, the case got appealed to the Fourth Circuit Court of Appeals. And based on this use of excessive force, Nally was disqualified from judicial service and convicted of deprivation of rights under color of law. There's an example where that actually happened. It was outrageous and unlawful. The judge was performing his judicial act of maintaining order. It's affirmed. Okay. So now let's get to Meyerless. This was a public defender case in California, and Superior Court of Appeals erred in ruling that Meyerless's alleged actions were not taken in his judicial capacity. There's an immunity from suit, and it can be overcome only if judge actions are non-judicial or taken in the complete absence of all jurisdiction. Since he ordered the bailiffs to do this, so here's the big key. Here's the takeaway. When the judge does the beatdown on you directly, no immunity. But if the judge orders the beatdown through the police, immunity, as long as it's in the courtroom and part of facilitating order. Howard Waco, a Los Angeles County public defender, filed suit in the district court against the Central District, is right here, against Raymond Meyerless, a judge at the California Supreme Court, and 2 police officers for damages. And he alleged that after he failed to appear for the initial call of Judge Meyerless' morning calendar, the judge, angered by the absence of attorneys from his courtroom, ordered the police officers forcibly and with excessive force seize and bring plaintiff into this courtroom. The officers allegedly, by means of unreasonable force and violence, seized plaintiff and removed him backwards, taking him out backwards from another courtroom where he was waiting to appear, cursed him and called him vulgar and offensive names, and then without necessity slammed him through the doors and swinging gates into the courtroom. Meyerless approved and ratified each of the aforesaid acts. Good lawyers know how to plagiarize the right things. It says here, Howard Waco, a deputy public defender in the Van Nuys, California. The Van Nuys Courthouse, I said Moscow, I was wrong. Van Nuys Courthouse, San Fernando Valley, been there many times. Informed that his client charged with a parole violation and missed the jail bus will not be present until 1:30 that afternoon. 2 LA County police officers approached Waco in the hallways and told him that the judge had requested that he appear before his court. He informed the officers that because his client was absent, he would be in Judge Alan Haber's courtroom addressing a procedural matter for another client. Waco proceeded to Haber's courtroom. Meanwhile, Miralles, angered that Waco had failed to appear, authorized 2 officers to bring him a piece or a body part of Waco. Although Miralles may have been joking, the police took this order seriously. They tend to do that. The Los Angeles Times news report described the resulting scene. A shocked courtroom personnel and spectators looked on. The 2 officers grabbed Waco and pulled him from Haber's courtroom. The officer dragged the protesting public defender, still clutching his legal files, backward down the hall into Miralles' courtroom. The officers pushed Waco into the courtroom, causing a deputy district attorney to scramble out of the way and Waco to suffer a bruised leg. The federal incident prompted Waco to sue Miralles and 2 officers in federal court under 1983, the Civil Rights Act, but the case was dismissed ultimately. Soon after he filed suit, Waco was transferred against his will to the San Fernando Public Defender's Office. Sounds like they didn't like what he did, because there are politics involved here when you take on a judge. We don't get to see this kind of drama that often, but it does happen. This judge was mad that these lawyers are not helping the cases to get through the system for whatever reason they can come up with. I've seen lawyers hanging out on the 9th floor at Moss Courthouse sipping coffee, pretending to be working on something, and the cases just stall because there's no lawyer present. So I think the judge was fed up and he knew what was going on. This guy's just goofing off, or maybe he wasn't goofing off, but judge wanted some stuff to get done and said, bring him in. Anyway, hope you enjoyed the video.